Welcome to our deep dive into the hidden penalty many people overlook when leaving the United States after an unauthorized stay. Today, we will unpack how voluntary departure can still trigger a 10-year reentry bar, what the lawful path back looks like, and how extreme hardship waivers work. To keep things smooth, we will move step by step, from the basics to timelines, pitfalls, and key takeaways. So by the end, you will have a realistic roadmap and the right questions to bring to a qualified immigration attorney. Here is our agenda. First, we will establish the big picture and define the 10-year unlawful presence bar. Next, we will explain why leaving the United States after significant unlawful presence actually activates that bar. Then, we will outline how marriage-based sponsorship interacts with waivers and what extreme hardship truly means. After that, we will examine timelines, risks, and common pitfalls. We will close with a helpful FAQ, quick quizzes, and a concise summary with next steps. Before we begin, a crucial disclaimer. The information provided here is for general educational purposes only and is not legal advice. Immigration law changes, and the facts of each case matter greatly. Watching this video does not create an attorney-client relationship. For advice tailored to your situation, consult a qualified immigration attorney licensed in the United States. Let's set the stage. If you accrued 1 year or more of unlawful presence after turning 18, leaving the United States activates a 10-year bar to reentry. Next, while marriage to a U.S. citizen can provide a path to sponsorship, it does not automatically cancel that bar. Instead, most people must pursue a waiver based on extreme hardship to a qualifying relative, typically a U.S. citizen or lawful permanent resident spouse or parent. Finally, depending on outcomes, you might either secure reentry through consular processing after approval or face the prospect of waiting out the full 10-year period abroad. The unlawful presence bar applies to people who have been in the United States without authorization for 1 year or more after age 18. The key trigger is departure. Once the person leaves, the 10-year bar to reentry activates. Importantly, this occurs even if the departure was voluntary and there was never a formal removal order. Many people believe leaving simplifies future immigration. But in fact, the bar often makes returning much more difficult. Marriage can enable a sponsorship petition, but it does not, by itself, eliminate the bar. Here is why leaving triggers the bar. Once you have accrued at least 1 year of unlawful presence, departing the United States activates a mandatory 10-year bar on reentry. At that point, your options become either living abroad for the full duration or attempting to return through consular processing, which will typically involve a marriage-based petition and a waiver application. If the waiver is approved, you proceed to the consular interview and, if successful, receive an immigrant visa. If the waiver is denied, you may need to remain abroad for the rest of the 10-year period or reorganize your life outside the United States. Let's compare outcomes. Leaving the United States voluntarily after accruing a year or more of unlawful presence triggers the 10-year bar, but usually does not leave you with a formal removal order. In contrast, being removed can trigger additional bars and often requires permission to reapply for admission via Form I-212, making the path more complicated. In both scenarios, if you want an immigrant visa through a U.S. citizen spouse, expect to address the bar and, in removal cases, possibly seek additional permissions. The bottom line, voluntary departure is generally less severe than removal, but it still triggers the 10-year bar and often requires a waiver. Now, the path forward. First, marry a U.S. citizen or rely on a valid marital relationship. Next, file Form I-130 to establish the qualifying family relationship. Then, assemble substantial evidence to prove extreme hardship to your qualifying relative, usually your U.S. citizen or lawful permanent resident spouse or parent. After that, submit a provisional unlawful presence waiver via Form I-601A, where available. If the waiver is approved, proceed with National Visa Center processing, schedule your medical exam and consular interview, and, if the interview is successful, return to the United States with your immigrant visa. Each step requires careful planning and accurate documentation. The waiver hinges on proving extreme hardship to a qualifying relative, typically a U.S. citizen or lawful permanent resident spouse or parent. The hardship must exceed ordinary difficulty. For example, severe medical issues requiring treatment available in the United States, significant financial dependencies, documented psychological impacts, and problematic country conditions can be persuasive. Evidence may include medical records, expert opinions, employment and financial documentation, psychological evaluations, and country reports. Note that children's hardship alone typically does not qualify for this waiver, though children's circumstances can support the overall picture of hardship to the spouse or parent. Here is a condensed markdown-style cheat sheet. First, confirm whether you accrued at least 1 year of unlawful presence, because leaving after that triggers the 10-year bar. Next, if you are married to a U.S. citizen or lawful permanent resident, file an I-130 petition to begin sponsorship. Then, evaluate your extreme hardship case and start gathering evidence early. A helpful tip is to collect medical, financial, and psychological records as soon as possible. Finally, discuss realistic timelines with your attorney and plan around potential multi-year waits. This table outlines key evidence categories commonly used in extreme hardship waiver cases. Medical evidence includes diagnoses and treatment plans. Financial evidence can involve tax returns, employer letters, and budgets demonstrating dependency. Psychological evidence may include evaluations and counseling records. Country conditions can be documented with official reports and credible news sources. Family responsibilities might include caregiving proof and childcare costs. Relationship evidence substantiates the bona fides of the marriage. Finally, an organized packet with a cover letter, exhibit list, and table of contents helps adjudicators follow your case. Avoid these pitfalls. Do not assume that leaving the United States will make the problem go away. It triggers the 10-year bar. Do not submit a minimal hardship packet. Depth and specificity are critical. Include country condition evidence and expert letters where appropriate. Follow National Visa Center and consular instructions carefully, and meet all deadlines. Avoid attempting to re-enter on a tourist visa or ISTA to fix status. This can cause serious issues. Given the complexity, consult qualified legal counsel, especially if your case involves prior orders, criminal history, or other complications. Quiz time. The question is, you stayed 22 months without authorization after turning 18 and then left the United States. What happens next? The options are: A. A 10-year bar triggers upon departure. B. No bar because you left voluntarily. C. A 3-year bar triggers. Or D. You can re-enter on a tourist visa immediately. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is A. After accumulating 1 year or more of unlawful presence, leaving the United States activates a 10-year reentry bar. Voluntary departure does not remove the bar, and a tourist visa is not a workaround to bypass it. Second quiz. The question is, does marrying a U.S. citizen cancel the 10-year unlawful presence bar? The options are: A. Yes, automatically. B. No, but it enables sponsorship and a waiver path. C. Only if married for 2 or more years. Or D. Only if you have U.S.-born children. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Marriage to a U.S. citizen does not automatically cancel the 10-year bar. Instead, marriage enables filing an I-130 petition and pursuing a waiver, often the I-601A provisional waiver, to request forgiveness of the bar based on extreme hardship to a qualifying relative. These are the key takeaways. First, leaving after 1 year or more of unlawful presence triggers a 10-year bar. Second, marriage enables sponsorship but does not cancel the bar. Third, the waiver is crucial and must persuasively demonstrate extreme hardship to a qualifying relative. Fourth, expect multi-year timelines and plan accordingly. Finally, involve experienced legal counsel to guide strategy and prevent errors. Let's tackle common questions. You cannot simply wait inside the United States to avoid the bar because it activates upon departure and governs reentry. Children are not usually qualifying relatives for the unlawful presence waiver. Typically, the qualifying relative is a U.S. citizen or lawful permanent resident spouse or parent. Waiver processing often takes months to years, so plan for an extended timeline. If the waiver is denied, options include waiting abroad for the remainder of the 10-year period or relocating together abroad. Because of the complexity and the consequences of mistakes, professional legal representation is strongly recommended. In summary, leaving the United States after a long period of unlawful presence triggers a 10-year bar to reentry. While marriage can facilitate sponsorship, it does not cancel the bar by itself. A successful extreme hardship waiver is often the decisive step. Anticipate multi-year processing and gather detailed evidence early. Given the high stakes and complex rules, consult a qualified immigration attorney to craft a tailored strategy. This Gantt diagram lays out a realistic timeline, starting with the I-130 filing in the first 3 months, overlapping with hardship evidence gathering through month 6. From month 6 to 9, the applicant files the I-601A and completes biometrics. The core waiting period is the waiver adjudication window, which can stretch from month 9 to month 24. Meanwhile, National Visa Center fees and document collection may occur between months 12 and 20. Toward the end, interview scheduling and the medical exam typically occur between months 20 and 28, culminating in the consular interview and, if successful, visa issuance around months 24 to 30. Overlaps indicate where preparation can happen during adjudication delays. Thank you for watching. If this video clarified the unlawful presence bar and the waiver process, please like the video, share it with someone who might need it, and subscribe for more practical immigration guides. In the comments, let us know your questions and experiences so we can cover them in future episodes.